Ladies and gentlemen, welcome back to the Chamber. I am your host, Andre Rocks, aka Shegun Agwu, the American refugee. And of course, you are tuned in to KYBN Radio 89.1 FM, the World Advantage Network. We've had so many lawyers come on this show and talk about qualified immunity. Attorney Carl Summerlock was on the show last week, and he really broke it down. And the feeling that I get, just as a layperson, not an attorney or anything like that, just the college dropout that has a face that they keep on radio, the feeling that I get is that qualified immunity puts you in a position where, yes, you have your civil rights, but you have no way to enforce them, or it makes it very, very difficult to enforce them or seek justice when those rights are violated. And it never made sense to me until my attorney handed me an article a few days ago. And I had to get in contact with the writer of this article, Professor Alexander Reinert, and it just blew my mind. And I'm not going to speak on it. I'm going to let the professor tell you what he found. So, ladies and gentlemen, welcome to the Chamber. Professor of Litigation and Advocacy at Benjamin Cardozo School of Law in New York, civil rights attorney for over 20 years with a concentration on fighting for the rights of the incarcerated. Professor Alexander, welcome to the show. I really appreciate you coming on today, sir. Welcome to the Chamber.
Thanks so much for having me. It's great to be here.
Well, I want to start off by asking you, can you break it down for the layperson? How has qualified immunity been practiced, and what is the problem based on your research and how it's been practiced versus, I don't want to give away the plot, but how it
Sure.
should have been practiced.
Yeah, sure. So first I want to start by saying I completely agree with you about the perverse nature of this doctrine. That is, we pretend that we have these constitutional rights and that our Constitution is the highest law of the land, and yet when it comes to enforcement, qualified immunity, amongst many other barriers to civil rights enforcement, makes it seem as if those rights don't exist. And it's something that is very hard for anyone to understand, whether they're a layperson or a lawyer, frankly. And so the article that I wrote really focused in on two issues. Qualified immunity was first introduced in 1967 in a case that arose out of the civil rights movement, that arose out of freedom riders in Mississippi who had sued police officers. And in that case, it's called Pearson versus Ray. The Supreme Court said, you know, this statute that was passed as part of Reconstruction in the 1870s that was meant to bring full enforcement to the 14th Amendment rights that were so important to Reconstruction. Mm-hmm. Well, the statute doesn't say anything about defenses. We're going to pretend that Congress meant to incorporate a common law defense that we're going to call qualified immunity. That was in 1967, and it's been elaborated ever since then. And just to give your listeners an example of just how perverse it is, this is a case out of Fresno, from the Fresno Police Department, mm-hmm. from 2019, in which the plaintiff said, you know, these officers, they came in, they executed a search warrant, and they seized money, and they stole more than $225,000. That's what the plaintiffs alleged in
Wow.
their lawsuit.
Wow.
And the Court of Appeals for the Ninth Circuit, which covers California amongst other states, said, you know what? Whether this is unconstitutional or not, we're not going to say, but it's not obvious that it's unconstitutional for police officers to steal more than $225,000 while executing a search warrant. Like, that's how perverse qualified immunity is.
Wait a minute.
2019.
Almost $250,000, and it's not obvious that that's illegal?
Yeah, that's what the Court of Appeals said. It's not obvious. It wouldn't be obvious to a reasonable officer that it's unconstitutional to steal more than $225,000 while executing a search warrant.
And when I was 16, I was arrested for stealing a Hershey bar. Gotta love it. Gotta love it. I'm sorry.
So what I did is I went back and I said, well, there's two mistakes that the Supreme Court seems to have made in elaborating this doctrine. The first is the assumption by the court that Congress, writing the statute in 1871, would have wanted any common law defense to be introduced into what is the most important civil rights statute in the history of our country, which is 42 U.S.C. Section 1983. And the Supreme Court assumed that even though that statute was silent about defenses, Congress must have meant to incorporate common law defenses. And so a lot of my article is devoted to rebutting that assumption that the Supreme Court made in 1967, and that really drives the rest of qualified immunity doctrine. And I do a lot of boring things that law professors do. Right? I read through all sorts of Supreme Court decisions from the 1800s to show that this assumption that was driving the 1967 decision was wrong. The other thing is that there was text that I call.
I know where you're going. I know where you're going with that, Professor, and I don't want to drop that bombshell on them quite yet.
Okay.
I know where you're going with that. So, in essence, how is the qualified immunity doctrine being practiced today, and how is that hindering the execution of justice?
Yeah, sure. So the most significant part of how the doctrine is being practiced is what it means is that if I'm suing a state official or a local official for a violation of my constitutional rights, whether it's a police officer or a corrections officer or really any state actor, and I'm asking for damages, they have a defense if they can show that it wasn't obvious, that it wasn't clearly established that what they did was a violation of the Constitution. And the Supreme Court has made that defense so powerful that usually or often for a plaintiff to overcome that defense, it has to show some prior case that's almost exactly identical to the case that the plaintiff is bringing in order to overcome the defense. So to get back to the Fresno case, right?
Okay.
What the court said is, well, there haven't been any prior cases in which officers were accused of stealing more than $225,000, so we can't say that it was obviously unconstitutional. Well, maybe the reason there haven't been such cases in the past is because as bad as officers can be sometimes, they haven't gone so far in the past as to steal more than $225,000 during a search warrant. So that's how it operates in practice, right? It's this huge barrier. And what it means is courts don't even ever. Sorry, go ahead.
Oh no! Please continue.
Yeah. So what it also means is because courts can decide the case based on the defense, they never actually tell us whether that particular conduct was a constitutional violation. So you lose in the first place because there's no quote-unquote clearly established law. But then the court doesn't tell us what the law is, so the next plaintiff coming down the pike also doesn't have any clearly established law to point to. So it's just this vicious cycle in which courts can take an off-ramp, decide there's no clearly established law, so the plaintiff loses, and we never learn what the law is so that the next plaintiff who's injured in a similar way also is faced with a qualified immunity defense.
So the court says there's no clearly established law, but then the court refuses to clearly establish the law for the next plaintiff.
Exactly.
That is, I mean, can you see the circular logic there? I know you can. I'm asking my listeners, can you guys see the circular logic there? Is we're not going to clearly establish the law, and then we're going to say that the law has to be clearly established in order for you to overcome qualified immunity. So basically what you have, if I'm understanding you correctly, Professor, is basically you have police officers and law enforcement officers hiding behind a shield. And it seems like the judiciary has intentionally created this shield.
Well, it's definitely a shield. you know, and it's a shield amongst many other shields. That is, there's already lots of ways it's hard to win, to even bring civil rights cases, and so this is just one additional barrier amongst many that civil rights plaintiffs confront.
Okay. So now I want to talk about your research, because correct me if I'm wrong. And again, I read your paper, and being a college dropout and not really being that smart, I understood about every third word you wrote, to be completely honest with you. But if I'm understanding the basic gist of your paper, this research is something that could tear qualified immunity asunder. Am I overstating that, or explain to me what you found?
Yeah, sure. I mean, I always want to be cautious about whatever impact my own scholarship is going to have, and I say that both out of humility and also because, as you said at the top, I've practiced civil rights law for more than 20 years, and so I know that even when you have good legal arguments, they're not always going to prevail. So I think if the Supreme Court reads the paper, and not just my paper, but there's lots of other people who've criticized qualified immunity in different ways, not for the reasons I've articulated in my paper.
Yeah.
But if the Supreme Court reads my article and accepts those arguments, then yes, I think it undermines
Well, there's a
the
difference.
very basis
There's
of
a difference.
qualified immunity.
There's a difference between what other people have, how other people have critiqued the concept of qualified immunity, and what you found, which is and the name of your paper, qualified immunity, being flawed. You found a fundamental flaw from its inception, and I'm going to let you get into that.
That's right. That's true. Yeah. So putting aside what I spent some time talking about earlier about sort of the way the Supreme Court interpreted the 1983 statute in terms of incorporating this common law defense, this is the other piece to the article, which is it turns out that when Congress enacted the original version of Section 1983, this foundational civil rights statute, back in 1871, they included language that I called the notwithstanding clause. And the language says that state officials or local officials shall be liable, that is, they are liable under Section 1983, notwithstanding state or local law or custom to the contrary. And so when you read that text, it speaks to exactly where qualified immunity comes from. And qualified immunity comes from common law immunity doctrine. And it seems like when you read that text, the 1871 Congress was saying, actually, even if there is some state law of immunity, a subject that other people have written about, even if that immunity exists, we don't want liability to turn on the existence of that immunity. We think there should be liability, quote unquote, notwithstanding that state or local law. Now, this was text enacted by the Reconstruction Congress in 1871. Mm-hmm. And yet, when this person called the reviser, who was asked to go through all the federal statutes and put them into one book, called the Revised Federal Statutes of 1874, he just left that language out. No,
what do you mean he left?
Why?
What do you mean?
He didn't have the authority to do it.
Wait. You mean?
I mean, he literally.
You mean to tell me? Is the reviser? Is he an elected official?
Not elected official. He was just chosen by Congress to go through all of the prior federal statutes and put them into one book. Up until that point, there hadn't been one book that had all the federal statutes.
So he's a glorified clerk.
Every time Congress enacted a law, it had been enacted. And so if you wanted to find the law, you'd have to go find exactly what was enacted in that particular year. And so then Congress said, we should have one book that has all of the federal statutes. Today, it's much more than one book, right? As so many federal laws on the books. But at the time, they said, we want one book. And that was what the revisers were supposed to do.
So, 1871.
And when he did it, he left that statute out.
Wow. So, 1871, the law was written. 1874, the reviser, this glorified clerk, is told, hey, put all these laws in one book. And when he put all these laws in one book, he, for whatever reason, omitted the section of the statute that essentially said, if I'm understanding this correctly, that qualified immunity doesn't really exist. Am I understanding this correctly?
Yes, it essentially said we don't want this statute to be defeated, to liability under this statute to be defeated because of some state law that says you can't sue officers because they acted in good faith and because they acted reasonably. You know, and it makes, I mean, we have to understand the moment, right? This is a moment in which the federal government didn't trust the states, particularly the southern states.
Right, we're just coming off of the Civil War. We're 6 years out from the Civil War.
Yeah, this is all part of the Reconstruction after the Civil War. And so the 14th Amendment, Section 1983, the 1871 Civil Rights Act, was all because Congress said we have these important federal rights and we don't trust states to enforce them. So it would make no sense for Congress to say, you know what, even though we're creating this new cause of action for you to enforce your federal constitutional rights, we're okay with a state like Mississippi saying, you know what, we don't want you suing officers when they act in good faith. So of course Congress wouldn't want state law to defeat this new important federal right of action.
Wow. So essentially, if I'm understanding this correctly, qualified immunity does not exist, at least on the federal level. It really just doesn't exist, and that language was omitted. How does this happen, and how does it stay on the books for so long without it being caught? Because to my knowledge, you are the only one who has brought this issue up.
Yeah, I'm the only scholar who's written about it. You know, that language, that notwithstanding clause language, you can see it in some scattered opinions, but no one's really ever made much of it before. I don't think anyone's ever really focused on what it could mean. You know, how this happened is really a mystery that I haven't quite unlocked. That is, I will say this, the reviser made a lot of mistakes. That first reviser made a lot of mistakes. This was not the only one. And wow. Congress very quickly said, you know, we need a second reviser because this first reviser made so much mistakes. But they couldn't do anything about the first set of mistakes that the reviser made. And so it leaves us in this very strange place where we know what the text was that the 1871 Congress enacted, and we know that it doesn't reflect what is currently on the books, but actually what is currently on the books is technically the law. So what it means, you know, to my mind is we have to read the current statute in light of what Congress meant for it to accomplish. And that's the most important lesson, I think, now, from my paper.
And I think that's a big question that I have is when Congress passes a law or an act, what is the official, is it what's actually in a situation like this? And I think that this situation, I don't think I've ever heard of a case argued about this. So I don't think that this is a precedented situation, but is the actual law what is written in the books, or is it what Congress passed? How does that work constitutionally?
So it's a great question, and it is one that actually has been litigated.
Oh,
and
wow.
So in general, it hasn't been litigated for this statute, but it has been litigated in other contexts. So in general, it's the law that Congress passed that controls, not the version of the law that got written down in whatever codification of the law the federal government creates. So that's the general rule. General rule is the actual text law that should control. There are some exceptions.
Okay.
And it turns out that this first revision from 1874, Congress, with not much foresight, decided in advance that the first revision of 1874 would be the law going forward. So once it saw all the mistakes that the reviser made, it changed its mind about future revisions. But unfortunately, as to the first revision basically controls in terms of what the law formally is. So again, this brings me back to the I think the lesson of the article is, even if the notwithstanding clause, even if one can't say that the notwithstanding clause is formally part of Section 1983, surely we can rely on it to understand what Congress intended to have happen with this federal statute, right?
So what then does that mean for the mountains of qualified immunity litigation that has been passed since then?
Yeah. Well, look, again, if the Supreme Court ultimately accepts this argument, and I think really the Supreme Court is the only court that can change its prior precedent on this, then they should take it seriously and say qualified immunity doesn't have any foundation. And I think that's what I'm hopeful. And as you generously said, this article is the only one that sort of has struck upon this particular argument about qualified immunity. I think if you cared about policy, there's lots of scholars who have shown that qualified immunity as a matter of policy is bad policy.
Oh, absolutely.
There's lots of other ways that scholars have explained how qualified immunity doctrine is wrong in other ways. So I'm always hopeful that the Supreme Court will read that scholarship, my scholarship, and scholarship of colleagues, and reconsider the wayward path it's taken us on qualified immunity.
Wow. If the Supreme Court were to hear a qualified immunity case, and your argument was to be accepted that the original writing of the law should at least be taken into consideration, if not, I guess the word is ratified and accepted as the actual doctrine. If the Supreme Court were to accept that, what would that mean for prior cases that have been tried but rejected due to qualified immunity? Given that the statute was written in 1871, and it seems to be at best that it was misinterpreted for so long, would those litigants have an opportunity to retry their case?
No, they wouldn't. And this is an unfortunate aspect of our law in general. Even when there's a change in some foundational doctrine like qualified immunity, the way courts treat it is the past, and this is, now we've got new law going forward, but there's nothing really to be done about cases that have already been decided and closed and are final. So it won't do anything for those folks, but it will do something, I think, for the future of civil rights enforcement.
Right. Right. And speaking of which, so you have you've been defending incarcerated people for the last 20 years, which, by the way, bad career decision, because generally those are not the people who have a lot of money to pay. But we honestly we do appreciate that your work. As a former incarcerated person myself, we appreciate your work. But what would that mean for people who are incarcerated, people who have been abused by police? I mean, I'm making this statement anecdotally, but from my time in being incarcerated and working in the law library and all of that, I can say that 1/3 of the people that came through there had very good evidence that the police had done corrupt things, and never went anywhere. What would this mean moving forward?
So I think it would mean, I hope, better enforcement of those rights. As I've said at different times throughout our talk here, there's other barriers to prevailing in civil rights cases, right? I mean, there's just the barrier of finding an attorney. There's the constitutional law itself makes it hard sometimes to establish constitutional claims, putting aside qualified immunity doctrine. Incarcerated people have to deal with statutory bars like the Prison Litigation Reform Act. So there's still lots of barriers, but it would remove one of them. And I think there's two things I hope it would accomplish. One is for people who have had their rights violated, I hope it will make it easier for them to enforce those rights. The second piece is I would hope that it would make violations less common, because at the end of the day, the whole point of bringing civil rights actions is to try and deter them from happening again in the future. And if every time a plaintiff sues, an officer gets off on qualified immunity grounds, then it's unlikely to deter a department or a set of officers from violating rights in the next case. And so one hopes that when there's successful civil rights litigation, that it also has an effect and reduces the number of violations moving forward.
Absolutely.
So that's the hope. Right?
And maybe I'm optimistic, but I see your research as having a greater effect on some of those other barriers as well. Because when we're talking about a litigant finding an attorney, everybody knows I'm fighting a qualified immunity case myself. We've talked about it on the show several times. And given the position I'm in, it made it a little bit easier. But financially, if I wasn't in the position I'm in, it would have been extremely difficult. But I think that's because you don't have a lot of attorneys who want to go toe to toe with cops, because it's hard to overcome qualified immunity. If the attorney had a better chance of winning, they'd be willing to take the case on a contingency basis. So I think we overcome that obstacle if your article and your assessment of the situation is accepted by the Supreme Court. I think, when there's money on the table, let's be honest here. If qualified immunity is out the window, there's money on the table. When there's money on the table, a lot of barriers fall down quickly. So I think that I'm sorry, go ahead.
No, I think you're right that qualified immunity is one reason that it can be hard to obtain attorneys in these kinds of cases. I think you're absolutely right. So if qualified immunity is no longer a viable defense, I think cases can become more appealing to attorneys who have to worry about their bottom line, for sure.
Absolutely. Well, Professor, we have about a minute and a half left in this segment. This is The Chamber, and one thing we do here, I think we are the only show on radio where we are a music/politics show. So we always, as we go into our musical break, we let our guests choose the music. So before we go into the musical break, number one, where can people find your article and other, because I've seen a few other articles that you've written and some YouTube videos that you've done with the university. Where can people find you, find your information, and especially read this article?
So it's easy to find me if you just Google my name, Alex Reinert, Cardozo Law School, and you'll find a webpage providing links to my articles. You could also search for me under the SSRN network, which has all of my articles posted, and they're free to download and read. This particular article is in the California Law Review, which is a law review that's published by the University of California Law School in Berkeley, and you can find it there on their website as well.
Awesome. So, ladies and gentlemen, the headline, qualified immunity really doesn't exist. Professor, before we go, what music would you like to be played out on so that we can take this into the musical break? Any song in the world that you'd like.
Oh, gosh.
I put you on the spot. I always do that.
This is the hardest question you've asked me.
Well, I've got to change my interview
So,
skills then, if that's the case.
Oh gosh. Let's try some iced tea freedom of speech. Can you get that on?
Iced tea freedom of speech. I wasn't expecting that, but a welcome surprise. Professor, thank you so much for coming on the Chamber. I would love to have a conversation with you in the future and just get your opinion on a few other things. So you are welcome here on the Chamber anytime. We appreciate you coming on. Iced tea freedom of speech coming up. We'll be right back here on the Chamber, ladies and gentlemen. Stay tuned.
Here we go. War. Yo, Tip, what's the matter? You ain't getting no stick. You bitching about rock and roll. That's censorship, dumb bitch. The Constitution say we all gotta.